wills and trusts. The importance of wills and trusts. A will and a trust are both legal documents that help individuals ensure that their assets are distributed according to their wishes after they pass away. While both documents serve similar purposes, there are some key differences between the two. A will is a legal document that outlines how a person's assets should be distributed after their death. It allows individuals to name an executor to manage the distribution of their assets, as well as to name beneficiaries who will receive those assets. A will also allows individuals to name a guardian for their minor children. One of the main advantages of a will is that it is relatively simple and inexpensive to create. However, there are some disadvantages to relying solely on a will to distribute your assets. For example, a will must go through probate court, which can be a lengthy and expensive process. Additionally, a will can be challenged in court by anyone who believes that they should have received more of the deceased person's assets. A trust, on the other hand, is a legal document that allows individuals to transfer their assets to a trustee, who then manages those assets for the benefit of the trust's beneficiaries. A trust can be revocable, which means that the creator of the trust can change the terms of the trust at any time, or irrevocable, which means that the terms of the trust cannot be changed. One of the main advantages of a trust is that it can help individuals avoid probate court. Because the assets are owned by the trust, they are not subject to probate court and can be distributed to the beneficiaries much more quickly and efficiently. Additionally, a trust can provide greater control over how the assets are distributed and can help minimize estate taxes. Now that we've discussed the basic differences between a will and a trust, let's talk about why both documents are important. Asset distribution. One of the primary reasons why wills and trusts are important is that they allow individuals to ensure that their assets are distributed according to their wishes after they pass away. Without a will or trust, the distribution of assets is left up to state law, which may not reflect the individual's wishes. Minimize disputes. By having a clear plan in place for the distribution of your assets, you can minimize the risk of disputes among family members or beneficiaries after your death. A will or trust can help prevent disagreements and ensure that your wishes are followed. Provide for minor children. A will or trust can also be used to provide for minor children or other dependents, ensuring that they are cared for and their needs are met. By naming a guardian and creating a plan for how their assets will be distributed, parents can provide for their children even after they are gone. Estate tax planning. A trust can be used to minimize estate taxes and ensure that your assets are transferred to your heirs with the minimum amount of tax liability. This can help preserve more of your assets for your loved ones and prevent unnecessary taxes from eating into your estate. Privacy. Trusts can also provide privacy by avoiding the public probate process that comes with a will. Because the assets are owned by the trust, the details of the distribution are kept private and are not subject to public record. Business succession planning. A trust can be used to plan for the transfer of a business to a successor after the owner's death. This can help ensure that the business continues to thrive and provide for the owner's family and employees. Overall, wills and trusts are important legal documents that can help individuals protect their assets and ensure that their wishes are followed after their death. It's always a good idea to consult with an attorney to determine the best course of action for your specific circumstances. An attorney can help you create a plan that meets your needs and ensures that your assets are distributed according to your wishes. When it comes to creating a will or trust, it's important to understand the legal requirements and ensure that your documents are valid and enforceable. In general, a will must be signed by the testator, the person creating the will, and witnessed by 2 or more individuals who are not beneficiaries of the will. The witnesses must also sign the will in the presence of the testator. A trust, on the other hand, typically requires the creation of a trust agreement that outlines the terms of the trust and the responsibilities of the trustee. The creator of the trust must transfer assets into the trust and name beneficiaries who will receive those assets. It's also important to periodically review and update your will and trust to ensure that they reflect your current wishes and circumstances. Major life events such as marriage, divorce, or the birth of a child can all impact your estate planning needs and may require updates to your documents. In addition to creating a will and trust, there are other estate planning tools that can help individuals protect their assets and provide for their loved ones. For example, a power of attorney can be used to appoint someone to make financial or medical decisions on your behalf if you become incapacitated. A living will can outline your wishes for end-of-life care and medical treatment. Overall, wills and trusts are essential legal documents that can provide peace of mind and ensure that your assets are distributed according to your wishes. By working with an experienced estate planning attorney, you can create a plan that meets your needs and protects your assets for future generations.